Hello everybody and welcome to Legal Concepts, educational videos for the study of law. This particular case concerns the topic area of contract terms, and we're going to be looking at a case which helps us understand specifically an exclusion clause. So when you're studying contract law, you're going to start with looking at contract formation, and then you're going to move into understanding how terms operate, i.e. hierarchy, where they come from. But firstly, you're going to look at the incorporation of those particular terms. So what we're going to do now is we're now going to move on to a particular case which is going to help you understand the incorporation of an exclusion clause when it comes to an unsigned contract. So you're having notice of the terms, and we are going to focus on a particular case to help understand how they operate. Okay everyone, so the case that we're going to look at today is Chapleton and Barry Urban District Council 1940. So not an old case in the world of contract law, but it's a key case that you will come across in your studies. And it's a very, very good way of re-establishing our knowledge of how a contract is formed, i.e. you want to make sure you have good knowledge, good understanding of offer and acceptance, because understanding how offer and acceptance operates and works will help you understand whether a term has been incorporated when we're looking at an unsigned contract. Okay. So Chapleton and Barry Urban District Council 1940, and I recommend that you have a read of this particular case. It's not a very long judgment, so in the early days of studying, this is a good win for you to read this particular case. So let's go through the particular facts of this case. Our claimant, as you can see, is a Mr. Chapleton, and Mr. Chapleton decides on a nice day in June to go to the beach, and he goes with somebody else, a Miss Andrews, and when they're at the beach they see that they can hire some deck chairs for them to sit nice and comfortably on the beach. So Mr. Chapleton decides to go and hire these deck chairs. He goes over to the attendant where there's a store where he can collect two of the chairs, so one for him and one for Miss Andrews at the time. And he's then, as he pays for the hire of the deck chairs, he receives 2 tickets from the attendant that's working. He says in the case that he doesn't really think much at the time. He's just handed these particular tickets, he doesn't glance at them, and he just pops them in his pocket. Now I think we can understand this is something that most people would do. Unaware though, there are some conditions on the ticket itself. Okay, and we're going to look at that very, very shortly, what that particular term said. Now, when he got the deck chairs, he sets them up on a nice flat part of the beach for him and Miss Andrews. But unfortunately, as he sits on the deck chair, the canvas breaks and he slips through and he hurts himself. So of course, he then wants to bring an action to the council being the one that facilitated this hire of the deck chairs. And he wants to bring obviously an action for personal injury, and this is where the problem arises. So let's have a look at what that particular term is. Barry Urban District Council, like any business or running a business, wants to exclude or limit liability. This is a practice that is recognized in law, And businesses and organizations can limit or exclude their liability. But as we progress, or as you progress through your studies, there are some limitations to that. Limitations now in legislation, but also limitations recognized in common law. So the term that Barry Urban District Council used was available for 3 hours, time expires where indicated by cutoff, and should be retained and shown on request. This is quite simple. It's saying that the hire of the deck chair lasts for 3 hours. But it also said that the council will not be liable for any accident or damage arising from hire of chair. Of course, this is going to be a really big problem for Mr. Chapleton, because Mr. Chapleton has sat on the deck chair, the canvas has broken, and he has hurt himself. Now, the term says that they are not liable for any accident or damage arising from hire of chair. The question is that term been incorporated? If the term has been incorporated, the second stage would be whether the term is reasonable or fair, subject to the current legislation that we have on it. So the question for the court is looking at the incorporation of this particular term, and hence why you need to then go back to offer and acceptance to really understand the judgment clearly. Now, why I recommend reading this particular judgment in full is, one, it's not a very long judgment, so it's nice for when you're starting to study law. But the judiciary make it very, very clear about how we consider offer and acceptance operating. And they are, of course, appeal judges, because Mr. Chapleton at the county court level lost his case. And the judge in the county court referred to a number of cases concerning railway tickets, and you'll look at them when you're studying this particular topic area. The judges on appeal said that the county court judgment had basically had a misunderstanding of how agreement works. And they look at the facts of the situation. They look at the kind of advertisement that was on the beach at the time. So Barry Urban District Council kind of advertising the ability for people to hire these deck chairs. And what they observe in an objective manner is that when they examined the process in which Mr. Chapleton could hire a deck chair, the language that was used was mainly centering around polite requests that they have to be returned and that somebody has to pay for the hire of the deck chairs for 3 hours. There was no notice of any term before Mr. Chapleton paid which stated about excluding the liability for any injury one may suffer if they were to hire the particular deck chairs. So the county court judge was treating this particular case as how we see railway tickets. And the judges felt that this was a misunderstanding. They highlight in particular that the local authority, Barry Urban District Council in this case, are making an offer to hire out the deck chairs. Mr. Chapleton accepts that offer to hire the deck chair, and the term, i.e. this term which tries to exclude liability, is presented afterwards. Therefore, it's not been incorporated, okay? Now, we have legislation which talks about excluding or limiting liability for personal injury, but specifically what this case is authority for is that notice of the terms must be presented to the offeree before acceptance. Okay, so when Mr. Chapleton sees the offer to hire the deck chairs and he accepts through handing over his monies, the term is presented afterwards where they're trying to exclude their liability. And on that basis, there's not a consensus, there's not a meeting of the minds about the terms of the agreement, and we can't incorporate that particular term after acceptance has happened. There's no clear incorporation of that particular term. So how would you summarize this in your knowledge and your understanding that terms have to be notified to the offeree before acceptance occurs, because if they are not, then they are not incorporated. And this is the point that the judges, and which they are all in agreement with in this particular case, that there was a misconception, a misunderstanding of the county court judges' interpretation of incorporating terms, and therefore Mr. Chapleton became successful, i.e. his appeal was allowed. So it's a great case, it's a simple case factually, but it's making you return to offer and acceptance, to understand how terms are incorporated, and it supports a particular idea, a very important idea in contract law, that there must be a meeting of the minds for an agreement to occur. So logically, if a term is presented after offer and acceptance, then it's not valid, i.e. it shouldn't be incorporated. Thank you for listening to this video, and please share with your friends if you're studying law, and of course subscribe so you get updates to any new videos that I make. Thank you.